to permit me to sum up, because I had submitted my arguments, and I had also handed over to your lordships three things, my lords. One was the judgments, which we had distinguished. The other was the timeline, my lords, with the crucial events as they unfolded. And the third was propositions and case law, which I have handed over. And then I had read out on the last day the crucial relevant paragraphs. Let me now just sum up some of the crucial events, because there's no point in my again getting into those timelines which your lordships have read and reread again and again. And we both will have our side to say on the timelines, my lords. My lords, firstly, it has been right through our contention that this is neither a case of merger or a case of split. Our case right through has been that a rival faction within the Shiv Sena is actually the Shiv Sena and is entitled to be recognized as the recognized political party under the symbols order para 15, which today has been accepted by the competent constitutional body, which is the Election Commission, and the matter is pending before your lordships. Now, till 2nd of July 2022, the entire allegation was a para 218 10th schedule allegation that you have voluntarily given up the membership of the party. And why have you voluntarily given up the membership of the party? Because you failed to attend a meeting at a 2-day notice. You failed to attend a meeting for the same evening, and the other where we never got a notice. And then the speaker, contrary to the rules, gives us 2 days instead of what is provided for. And it is at that stage that we approach this honorable court saying, A, violation of principles of natural justice, B, threat to our life in the state concerned, and 3, relying on Nabam Rebia to say that constitutional propriety requires that the speaker should first decide his own removal before deciding disqualification. So, my lords, till 2nd, it's only a 2-1A case. And our respectful submission is, my lords, that internal dissent is the essence of democracy. And in repeated judgments your lordships have held that merely because within a party, people are aggrieved by what is happening, question the leader, question the chief minister, even from the same party, is not a 2-1A case at all. And that is exactly what your lordships held in Balachandra versus Yadurappa to say that even where from within the party, the chief minister of the same party was questioned as continuing, it was held that this was not a 2-1A case at all. So I don't have to rely on any defense at all of para 3 in any case which doesn't exist, or para 4, because I am saying that as far as I am concerned, this is the party and I have been recognized today as the rival faction within the party. And definitely questioning and passing a resolution on the 21st, which categorically said that there is overwhelming resentment with the fact that we are continuing in a coalition, or were continuing in a coalition at that time, with a party which has been politically and ideologically opposed to us for decades, is causing great amount of resentment amongst the cadres and the party workers. So that is the resolution which reached the governor. Now, at this stage, my lords, so 2-1A, our respectful submission is this is not a case at all of a 2-1A case. In any case, my lords, whether it is a 2-1A case or a 2-1B case, who will decide that? The argument being raised before your lordship says these are per se cases, because we say so, it is per se case, nothing else is required, and your lordship should bypass the entire constitutional machinery of coordinate constitutional authorities and decide it yourself, without the speaker having decided the issue, because today we feel the speaker who ought to have been there is today not the only person. He's still the deputy speaker. There's a speaker in place who will be biased. So you decide the whole thing. This is the legal argument being made before your lordships. Contrary to every judgment on the point, including Quixote, that your lordships will not interfere till a final decision comes from the speaker on the point. Now, my lords, as far as the second part is concerned, which is 2-1B, which really commences on 2nd, because then we are looking at 2 rival whips being issued. And our whip, as I had said, by an overwhelming majority of the legislature party had been appointed on 21st of June itself. They on the same date reiterated their faith in their earlier continuing whip. Now, the fundamental mistake in this argument is as if what is happening is only in the legislature party and not in the political party. And our argument on that, my lords, repeatedly has been that these are co-joined, integrally connected, organically connected, and each influences the other. And that is why, my lords, I had read out to my lords on the last date, even para 4 of Schedule 10, which categorically provided that a deeming fiction that for a merger of a political party, if 2/3 of the legislature party merges, that is taken as a merger of the political party, as an indicator that you can't segregate the two. Because this whole argument is based is that it's only the political party, it's only the legislature party, not the political party. We also draw strength on what we are saying, my lords, from the symbols order, which itself provides that for the continued recognition and existence of a political party, the number of votes polled, the number of MLAs and MPs which form the pool are all part of the continuing existence and recognition of a political party. We also draw sustenance for our argument from Sadiq Ali's paragraph that I had read out to your lordships on the last date to say that percentage of votes, number of MPs relying on the symbol orders is an important integral indicator for a continuance of a political party and is to be taken into account when the EC decides the matter. So, my lords, to say that you just represented the legislature party and not the political party is a complete fallacy and misreading of the law and facts, because this has been no one's case ever. In fact, our resolution consciously reflected the dissent within the party. The resolution did not say that it is just the legislature party. It talked about the political workers, the political party in question. Now, my lords, as a practice there, I had also respectfully shown to my lords on the last date the Maharashtra Legislative Assembly rules that at the end of the day, who is the speaker in touch with? The speaker is necessarily reliant, my lords, on the leader of the legislature party when it comes to recognizing a whip. Because under the rules, a member is elected as the leader of the legislature party. The legislature party's leader is the one who is in touch with the speaker. The leader of the legislature party indicates to the speaker the various designations and posts held by the people. The leader of the legislature party also indicates to the speaker under Rule 3, Subclause 4, any change which occurs. So today to say that the speaker in exercise of his power under Para 2(1)(b) of the 10th schedule will embark on an inquiry into the issues of the political party and will not confine himself what to the whip or the leader of the party says is wrong. Because A, he cannot do it, he doesn't have the wherewithal. A political party is a much larger amalgam of taluka leaders, of district workers, of political workers, or parties. It's the ECI which is the constituted constitutional authority which goes into it and has exercised its jurisdiction, was at that time wanting to exercise its jurisdiction when your lordships were asked to stay that. And your lordships refused that stay, saying that that order must come from them. So the speaker does not embark on that inquiry at all. Now, even when Para 3 existed, my lords, and I'm purposely now not getting into judgments again, even when Para 3 existed, my lords, in Rana, your lordship said two significant things: that the speaker will not embark on an independent inquiry as to a split in a political party. He holds the issue of disqualification. And as far as the issue of disqualification is concerned, it's a prima facie view that the speaker will take. Because what is being asked today is that the speaker will usurp a power that the speaker does not possess and will get into the politics of the political party. Of course, the first presumption being that they are two independent and thus an inquiry must be carried out there. Now, my lords, the practice of the legislature party of the Shiv Sena right through, my lords, has been, and those two letters have already been shown to my lords, also handed over. One is part of the record, the other was handed over, where it is always the legislature party or the leader of the legislature party which writes to the speaker to say who is the whip of the party. There is no doubt that in overwhelming MLAs, the majority appointed Mr. Gogavle as the whip, and that the earlier whip was removed. There is no doubt about it. Now, today, we have a situation, even from 2nd of July, if it's a 2(1)(b) case, we have two rival whips issuing two rival directions, presuming They are right and there was a rival. So there are two rival whips as per them. Now, who will decide this? Again, the same argument of 2-1A. Your lordships are being told that per se, because we feel they have incurred disqualification, your lordships are not required to send it to anyone. And please decide it yourself. And that is a common thread that I'll keep coming back to, because your lordships are being asked, first your lordships are asked to bypass the election commission, which your lordships refused. Now your lordships are being asked to bypass the speaker, which your lordships have to consider. And the third issue is of the governor, which I'll touch upon separately, my lords. So three coordinate constitutional authorities vested with independent specific powers and areas of concern and interference which they have to deal with. The governor deals with, does the chief minister and the government enjoy a majority? Is there political accountability? Does he enjoy the majority on the floor of the house? As far
See, the difficulty is rising because you're formulating this principle of prima facie determination by the speaker. So the defense that you would take as against a case of a split would be that there is actually a realignment of the political party and that you are the political party. Those defenses are all right, but we have to formulate the principle with respect to the decision that the speaker is going to take at this stage. As I was indicating earlier, it may be a jurisdictional fact. Here, the distinction between a split and the case that you set up, that it is actually a case where you control the political party, is very thin. So it's very easy for a speaker at one stage to say prima facie, I think that it is there, or very easily he can say prima facie, I don't think it's not a case. So to formulate that principle, that speaker will take a prima facie view and come to a conclusion that it is not a case of a split, but it is a case where you have set up the control over the political party.